Okay, let's go back on the record. Which case you want called first?
I guess we can take Mr. Harrison's one. Discriminatory for the state.
Okay, we're calling Mr. Pinkerton's case at this time. Names for the record, please.
Discriminatory for the state.
And good afternoon, Your Honor. May the record reflect the presence of Chris Pinkerton as well as his counsel, Bill Harrison.
All right. The matter was actually set for trial in case LC-06-27, single count, petty misdemeanor harassment. Is the matter proceeding to trial today?
So, Your Honor, I would ask that the matter not proceed, and I would move to continue the case, and also I'd have to move orally to withdraw as counsel in the matter. And I beg the Court's indulgence to allow me to do that orally because of the fact that I didn't have the time nor the resources because of my secretary to have prepared a written motion.
Okay. Before I hear argument on any motion, Mr. Pinkerton, Mr. Harrison is orally moving the Court to allow him to withdraw as counsel in this case. I would assume since he represents you in other cases that at some point in the future that request would come up for the other cases. But right now I just have the one petty misdemeanor harassment case on my calendar. In most cases, what occurs is that when a motion is filed, it's in writing, it's filed, and we schedule it on a Wednesday morning. And so since Mr. Harrison flies in from Honolulu for his court appearances in your cases, the Court, as long as there's no objection to having a hearing on an oral motion to withdraw as counsel, the Court can proceed with a hearing on that motion at this time. But I need to ask you whether you have an objection to proceeding with a hearing on the motion to withdraw as counsel. And if you do, I'll hear your arguments. Not with respect to the motion itself. I'm just asking you right now whether or not you object to the Court hearing arguments from Mr. Harrison, yourself. You'd be able to make any statements you want, as well as from the State on Mr. Harrison's request for permission to withdraw as your counsel in the case today. Do you have an objection to the Court hearing arguments on that oral motion today?
No objection to the motion.
Okay. So there's no objection to it actually proceeding for a hearing on the motion to withdraw as counsel for Defendant Pinkerton. State's position on that motion?
Yes, he doesn't object.
All right. Mr. Pinkerton, Mr. Harrison is asking permission to withdraw as your counsel in this particular case. Do you object or not object to having him withdraw as your counsel in this case?
I do not object.
All right. No objection from the defendant being raised. The Court will grant the oral motion of Mr. Harrison to withdraw as counsel in the case. There is also an oral motion to continue the trial. State's position on that?
I guess that will depend on, well, there's no objection to continuing the trial since Mr. Harrison will be withdrawing. I guess it's just a matter of how long the defendant will take to get new counsel. All
right. Mr. Pinkerton, because the motion to withdraw has been granted by the Court and this case is pending trial, the Court's not sure whether you will be seeking new counsel to represent you or assist you in the case, or whether you are going to ultimately decide that you want to proceed on your own. In any event, the Court feels that it is appropriate and it's reasonable to grant a continuance of the trial date since you're not going to have your counsel representing you at the trial. So how many weeks would you prefer to continue this matter so that it would give you adequate time to either secure the services of another attorney or to make a decision that you want to represent yourself and for yourself to prepare for trial in this matter?
24 weeks, Your Honor.
That's a little too long. I was thinking more, do you need about 3, 4 weeks, 5 weeks max? Because the case has been pending for a while. Mr. Harrison, you have all of Mr. Pinkerton's files in this matter?
I do, and
all right.
I'll be more than happy to supply new.
Okay, he will be able to get you all of your discovery and any pleadings that have been prepared in the case. So the Court's willing to grant the continuance of the trial date, but 24 weeks is longer than what we even set on cases where you get counsel right at the beginning. So what we're going to do is I can give you, does the state object to a 5-week continuance of the trial date, Mr. Minatoya?
No objection, Your Honor.
All right. Mr. Pinkerton, what we're going to do is I'm going to continue this matter. Do we have a time slot available to set trial? Approximately 5 weeks. I think we got a... Huh? Okay.
Your Honor,
Yes.
can I request that the courts combine all the charges from all the arrests into one?
Well, they cannot be combined into one case. All right. Do you know offhand, I know he's got one matter that was continued for a preliminary hearing. And that's on a different calendar, so that's at 1. And I can't combine that with the trial times. But
That's correct, and there's also been a jury demand on another misdemeanor matter that's up with...
okay, so to your knowledge, only 3 cases currently pending, right? Prelim hearing, harassment, and then jury demand.
It's...
Hold on, we're double checking.
There's 3.
3 in district.
Mark Greifer, State Judge, there's 2 in district and 1 that's set for a prelim, so that would be the 3rd case, which we have not.
And then 1 up on a jury demand.
That's correct.
Okay. Just hang on, we're pulling up the information on our computer system.
August 3rd for prelim
Yep.
on the charges
Right.
of resisting arrest, assault.
Right. Okay, that one is set for August. And in addition to this harassment and that prelim hearing case, is there another case?
Not that I know of, except with this one went over to
We're showing a total of 3 cases. The prelim case is set now for August. This case,
and that's it.
and the one that's up at circuit on a demand.
Yeah.
All right, Mr. Pinkerton, this is what the situation is. To the best of what we can determine right now, there are a total of 3 cases that you have pending in the 5th Circuit. One case is a case which has been continued to August 3rd. That was for your preliminary hearing. And that is set currently for August 3rd at 1 p.m. That's when we have all our preliminary hearings set. Trials in non-felony matters in the district court are held on Wednesdays at 2 p.m. And so we need to find a continued date for this case right here, this harassment case. The 3rd case that you have, according to our records, there was a demand for jury trial. So that is not in my courtroom. It is now up at the circuit court. And so for any scheduling questions that you may have, you will need to deal with the circuit court judge. All right? But I can handle the scheduling on this case, the rescheduling for trial. It cannot go on the same time frame as your preliminary hearing because the felony matters are handled on a different calendar, albeit in the same courtroom. So it's a matter of us finding an alternative date for your trial in this single count harassment case. And if we take it about 5 weeks out, July what? So Wednesday, 5th.
July 5, 9 o'clock, there's 2 could die for 5 hours, and then for 2.5 hours.
And what do we have in the afternoon set?
Except for could die carry over from the
It's free except for that. Okay. We can set it on Wednesday, July 5, or what about the 12th? Are we open on the 12th? That's all. Nothing in the morning. Okay. So I can set it for either Wednesday, July 5 or Wednesday, July 12 at 2 p.m. It would essentially be second set on the 2 p.m. slot. Witness problems on either date?
I know I'll be out of state for training on the 12th, but I'm sure somebody else can cover the trial.
And the 5th, you have a choice of the 5th or the 12th. July 5th or July 12th, both Wednesdays. And it would both be a trial set at 2 p.m.
12th.
The 12th, okay.
Please.
We will continue the trial to Wednesday, July 12th at 2 p.m. in this courtroom. time charge to defendant. So we now have your two matters that are still in the district court on reset dates. Just as a reminder, prelim hearing, August 3rd at 1 p.m. in this courtroom, and trial on the harassment charge in this courtroom Wednesday, July 12 at 2 p.m. Okay?
Yeah,
Yes.
in the event that the defendant retains a counsel in this matter, I'd like to request that pretrial conference take place
Okay.
as well.
Mr. Pinkerton, what's going to happen is Mr. Harrison is going to turn over your case files to you, and you can get that done within the next week.
Yes.
Okay. So within the next week, you will be receiving your case files, including all the relevant police reports and discovery from Mr. Harrison. If you do retain counsel or you consult with an attorney to try to hire an attorney to represent you in the case, you may share that discovery with the attorney. But the police reports are not to be copied. They are not to be published. They are not to be disclosed or shared with anyone. Okay? So you can't go out and you can't disclose them to anybody else. The only person you may disclose those police reports to is an attorney licensed to practice law that you are consulting with an eye to retaining that person to represent you, or if you actually hire an attorney. They are not to be posted on any internet site. They are not to be Xerox copied or shared with anyone else.
Your Honor?
Yes.
I already do have some police reports posted on an internet site.
Okay, well, I'm telling you that the discovery that is going to be turned over to you in this case from Mr. Harrison is not to be posted, is not to be copied, and is not to be disclosed to anyone other than an attorney representing you or an attorney that you are consulting when you're thinking about hiring that attorney. All right? Now, if you do, in fact, hire an attorney, as soon as you retain that counsel, your attorney is to contact Mr. Minatoya, so that Mr. Minatoya is able to understand who's going to be representing you, knows who to communicate with. And then if a pretrial is going to be requested as soon as counsel is discovered, Mr. Minatoya, you can always call and we can schedule a pretrial. All right?
Yes, Your Honor.
Okay. Mr. Harrison will need to prepare an order granting the oral motion to withdraw as counsel. And actually, on the other matter, if Mr. Pinkerton is not going to object to a withdrawal of counsel on the other matter, then you need not file a motion. You can actually file a withdrawal where it's clear that he is signing and indicating that he consents to the withdrawal.
Thank you, Your Honor.
All right.
I just spoke to him, and he did indicate he would consent.
Okay.
So, and one other housekeeping matter, Your Honor.
Yeah.
I have a stipulation order continuing prelim that we have prepared.
Oh, okay, for the August 3rd date. Okay. Thank you. Okay, so I'm just signing that and continued. We can just file it right here.
Okay. I made copies. I apologize.
Right. Okay, I think that's all. Mr. Pinkerton, can you stop at the bailiff's desk? Thank you.
Do you have copies?
Yes, I would like some. I was running out of the office this morning to get here, and I apologize.